concern of
DP, you are there?
Lordship.
Heard DP Jamil and the counsel for the appellant. On request made by Muzui, the counsel for the respondent. List the matter after.
on 28, Lordship, on 28 February.
28 is Tuesday. Let it be first, which is 1st March.
First March, Lordship. Yes, 1st March, Lordship. Obliged, Lordship.
May I please, Lordship? Lordship, I also like to mention admission item number 38 and 39.
38.
8 and 39, Your Lordship. I have taken the consent of the counsel for the petitioner, Your Lordship. If I am yet to file counter affidavit, if I may be given 3 weeks' time to file counter affidavit,
Yes, challenging the rules.
Your Lordship.
Heard is all and the counsel for the petitioner. On request made by Mr. DP Jamil, Leonard,
I am for respond number 2, 4, and 5.
for the Leonard counsel for respondent 2, 4, and 5. How much time?
3 weeks, Your Lordship.
3 weeks' time is allowed to file counter.
My lord, I'm appealing for respondent number 1 and
List
3.
the matter up to 3 weeks. Mr. Thipapong, Leonard counsel, the government advocate appears on behalf of respondent number 1.
Obliged.
Much of that.
Lordship, I'd like to mention item number 51 listed for hearing.
Item,
51.
pull the mic.
Item 51.
Yes, please.
On the last occasion, the matter was listed before your lordship, but your lordship has expressed difficulty to
In
take
this
up the
matter?
matter. That's why my senior has entrusted me to make a mention for the matter to be listed after the election.
Your Lordship, it relates to school education department.
Oh, okay.
Yes, yes.
Okay. List this case before any other bench without one of us, within bracket, put my name.
Much obliged. After election, lordship, matter to be listed after election.
Anyway, I can't pass any order to this.
Yes.
For motion, item number 1.
Delay.
Yes, Lordship. I must start with an apology, Lordship. There is some mistakes in the numbering of the paragraphs, so I may be allowed to make some corrections.
Iralu, you entering appearance?
Lordship, yes, I am in regard to R4.
In the IA?
No, in the main,
Do you have any objections in the IA? It's
No.
about 22 days only.
no.
Okay, heard City Jamil and the senior counsel assisted by Mr.
Aliba
Ali
Ozekam.
Ali Bauzukam, learned counsel for the applicant. This is an application paying for continuation of 22 days, is it? Or 28 days.
28 days.
Delay in filing the connected writ. Stop. Mr. R. Iralu, learned senior counsel, assisted by Mr. L. Iralu, learned counsel, appears on behalf of the
R4.
respondent number, there's MS Z Rulho,
Yes.
Yes, Your Lordship.
appears for respondent number 4, and Mr. M. Kim Sung, learned additional AG, appears on behalf of respondents.
1 to 3.
Okay, 120. Put in Kim Sung's name first. Stop. Learned counsel for the respondents submits that they have no objection if the delay is condoned. Stop. We have also considered the course shown in the IA and we are satisfied. Accordingly, delay of 22 days is 28 days is condoned. Stop. List writ appeal will list it.
Up to 3 weeks, Lordship, but respondent number 5, notice may go to respondent number 5.
No, in the IA I have condoned.
Yes.
Writ appeal is writ appeal is numbered.
Writ appeal 1. Actually,
How is
it should be numbered after
after
the delay is
condonation?
condoned.
What do you do with the bill? Okay, then we issue notice. Head City Chairman, then the Senior Counsel, assisted by Mr. Ali Bauzakam, then the Counsel for the appellate. Issue notice. Mr. Im Tim Sung, then the additional age appears for respondents 120. Mr. R. Iralu, then the Senior Counsel, assisted by Mr. M. Iralu, then the Counsel appears for respondent number 4. Stop. Appellant to take steps for service of notice on respondent number 5 by registered post AD within 1 week.
Yes,
1
Lordship.
week. Okay. Please matter after 4 weeks.
Obliged.
Shall we take up here first?
For admission, item number 2 and 3.
Lordship, other matters may be exhausted first, thereafter this item may be taken.
Call up item 4.
For admission, item number 4.
Yes, have you filed your affidavit?
Your Lordship, I think to apologize before the Lordship because of the winter break, there was some time has consumed. So I have collected some documents for the recruitment process. So I may be allowed to submit.
You are supposed to file an affidavit explaining everything, not by producing documents.
Okay, then I may be allowed a short time
I'll give
to
you
file.
1 week time to file affidavit.
My lord.
Heard, Mr.
K.R. Khan, Lordship.
K. R. Kha, Learned Counsel for the petition. Stop. Mr. Im Tim Sung, Learned Additional AG, submits that he'll be filing affidavit in terms of the order passed by this court on
1412.
on 14/12/2022 within a period of 1 week.
Lordship, Lordship,
The prayers are up. If no affidavit is filed by the next date fixed, this court will be constrained to pass appropriate orders against the erring respondents.
Lordship, in the
This
meantime,
after 1 week.
in the meantime, Lordship, as a stopgap arrangement, around 15 employees from the directorate, including drivers and peon and administrative staff, have been deployed.
No, that's fine, that's fine. We'll consider that on the other day.
Lordship,
Let us see the affidavit.
Yes,
Let
sir.
us peruse the documents.
Lordship. Obliged.
Obliged, Lordship.
For admission, item number 40 to 48.
May I please, Your Lordship? My Lord, in the last occasion, by order dated 7/7/2022, delay has been granted. However, that now that IN number 92 is for stay. So my humble prayer is stay may be granted and the matter may be fixed for hearing, my Lord.
Where is the writ appeal? Delay of how many days?
66 days.
That was condoned.
Yes, my Lord. By order dated 7/7/2022.
Who is that IA?
Uh,
Who is the disposed IA?
IN number 91.
91. Go. Yes. Let's see the judgment.
Your Lordship, may kindly see in Bharat 6, page number 66.
No. Let's see the impugned judgment.
Yes, impugned judgment, page number, in Rate Bill number 16, page number 66.
16, page number 66.
Yes.
Page number
66. Relevant paragraph start from 6. Para 6, yes, my lord.
66.
Yes.
Yes.
May I read, my lord? It is true that the petitioners serve as workers to labor and they continue their service though they were never regularized. But it must not be forgotten that for people who serve in that kind of employment with such wages, salary, it is not by choice but by compulsion of needs. Therefore, the welfare state, instead of taking advantage of the compelling circumstances they are in should have taken up measures for providing better conditions of service and should also have regularized their service. To do so would have been most just, equitable, and reasonable after all the service had been utilized for the best part of their lives. However, the state government does not. Uh, However, the state government choose not to take any action to elevate the service condition of the petitioner. Right to
These
life.
petitioners, they have all retired.
Yes, my lord. They have served for 35 years on fixed pay. They have retired. So by
There is a judgment of the Supreme Court, isn't there? There's a judgment passed by the Supreme Court
yes, they are
in similar matters.
yes, my lord.
A review was filed.
Yes,
What is the
that
stage of that?
my lord, that SLB was already disposed, and that SLB and this matter is not relevant because in that SLB, petitioner husband was expired before the expiry of his service, and here the petitioner they have after completion of 35 they will die. So that is the
They have
difference.
retired.
Yes. So here our stand is, my lord, here, single bench has directed the respondent to regularize the petitioner service for pensionary benefit. So for regularization of service, there is governed by one office memorandum, that is 07/2015 OM. That is, in that OM it says that those who have completed 30 years and enjoying scale of pay. Here the petitioner, they are not enjoying scale of pay. Though they have completed 35 years, but they are not enjoying scale of pay. So there is no office memorandum, there is no scheme for granting of scale pay. So until and unless they are considered scale, that scale pay, they are until and unless they are getting scale of pay, their service cannot be regularized. That is the stand, my lord.
You are appealing for?
I'm for the respondent, Your Lordship.
For the respondent.
Yes,
In
Your
all the
Lordship.
matters?
Yes, my lord.
In all the cases?
Yes.
So my humble praise.
Heard Mr. T. Bapom, learned counsel, learned government advocate for the appellants. Mr.
Benison Vishoy.
Penny,
Benison Vishoy.
you know the name, learned counsel, and to appearance on behalf of the sole respondent. Stop. Admit. Call for records. List the matter. After
3 weeks.
3 weeks, in the interim, the judgment in order, the command judgment in order. The 24/3/2022, isn't it?
Yes.
Correct?
Yes, my lord.
Shall remain suspended till the next returnable date. Stop. In the IA, you write, in view of the interim order passed in the main writ appeal, IA stands disposed. Same order in all the cases.
Much obliged.
You are appearing in all the matters up to item number 48.
Yes, Your Lordship.
You are appearing in all.
Yes.
Same order you pass. And IA all IA will be dismissed.
For hearing, item number 50.
For a considerable period of time, the parties were engaged in the negotiations. At one point of time, they have almost settled the issue. However, recent past, there is some development. So some time will be given, about 2 weeks. We will try to resolve it out of the court, Lordships.
Yes, Your Lordship, actually, we tried our best. Then finally, it confined to about 3-4 hectares of land. Then we decided, we offered to divide it equally. One village accepted, one village declined. Then we persuaded my villagers to concede. So accordingly, we came to an agreement, we signed an agreement, we prayed. We decided for partition of the boundary. But then the other village are having second thoughts over it.
Okay.
So we'll proceed. So
Learned counsel for the parties submits that the parties are trying to settle the matter outside court. And therefore prays for listing this matter after 4 weeks. 4 weeks will be sufficient?
Lordship.
After 4 weeks. Prayers are not list accordingly.
Obliged.
For admission, item number 2 and 3.
Yes, 1, 2, 3.
Yesterday, Lordships, I have stopped in a time when I was about to finish.
Okay.
So only on the facts, there are 3 documents left to be referred, Lordships. So I would like to refer to your Lordships to page 101 of the writ petition. Here also I need not read. Both Lordships are well conversant with this act, Nagaland Retirement from Public Employment Act. I have just enclosed this so as to show that the employees of the Nagaland Legislative Assembly is governed by this act under the definition of public employment under section 2. Only for that purpose I have enclosed this, Lordship, so no need to read also. And then this will have a relevance with regard to the fixing of Retirement Act up to 60 years only. And beyond 60 years, then Act doesn't permit. So 1 Anthony, there is some provisions in the amended rules, making it up to 65 years. So in that context, this will be relevant. Next page is page 102, Annexure Q. This is only to show that the latest amendment of 2019 Act has fixed the retirement age to 60 years of age and 35 years of length of service by section 3, clause 1 and 2. Only for that purpose, I have enclosed this document also. Since Lordships are well aware about this, let me not read that document also. Kindly come to page 103. This is an office memorandum by which the private respondent number 3 has been upgraded to the post of additional secretary transport, and brought to the schedule under the rules. Therefore, this was challenged by in a writ petition, WPC number 323 of 2021. 4 affected officers have filed this writ petition, and in that case, this notification office memorandum has been quashed. Not only this, the next annexure also, but for our reference, I may be allowed to read this.
Upgraded to which post?
Upgraded to the post of additional secretary. May I read the entire office memorandum because this will have relevance. This is 1st November 2021. Office memorandum. In exercise of powers conferred by the proviso to Article 187 of the Constitution of India and in accordance with the authority vested under Rule 19 and Rule 22 of the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rules 1999, Second Amendment Rules 2012 incorporated. The Speaker, Nagaland Legislative Assembly is pleased to restructure the gather of the upgraded post held by Srimati K. Rao, that is the present respondent number 3. Transport, presently, K. Held by Additional Secretary Transport, White Secretariat number so and so, dated 30th November 2019, and accordingly decided to order for the encadrement of the upgraded post of Additional Secretary Transport, presently figuring in 3rd Schedule T and placed in the 3rd Schedule A to this Secretariat Service role, hereinafter called the General Cadre, with immediate effect. Consequently, Srimati K. Rao, Additional Secretary, shall be accommodated against the substantive post subject to availability of vacant position in the same rank. She shall also be assigned, allocated with additional responsibilities as deemed required and necessary by the administrative authority. Consequently, the competent authority had also decided that in view of the above revised cadre structure exercise, the post of transport officer substantively held by Srimati K. Rao and currently figured under 3rd Schedule T shall be automatically placed at 3rd Schedule A, and the post of transport officer shall be filled up by the subordinate officers in the next immediate lower rank enlisted under 3rd Schedule A through promotion after the due scrutiny by the DVC. The category of posts other than those mentioned referred to in this office memorandum remain unaltered and shall continue to be categorized as per the existing 3rd Schedule A to the 3rd Schedule H of the Secretariat Service roles enforced. The notification of concomitant amendment in the recruitment and conditions of service roles for the above post will follow. These issues with the direction of the Honorable Gauhati High Court, Kohima Bench, in the case of WPC number 20 of 2021, dated 14/7/2021, and relying on the decision given by the then Honorable Speaker on 6/8/1996, where the nature of the post was intricately defined as the general cadre. So I would refer to the last paragraph. Here, one writ petition number has been referred, and the other is the decision of the Honorable Speaker, which was given on 6/8/1996, showing that it is a general cadre. So on this point only, I would like to just make a little highlight. The writ petition of 20 of 21, which was disposed of on 14th of July 2021 it was disposed of on the day of motion, and this petition was filed by the respondent number 3, the present respondent number 3. She has submitted a representation requesting the authorities to bring to the cadre, and that was pending, but authority could not take any action. Within about 2 months, she approached this honorable court by filing this WPC 20 of 21, and made a prayer that, look, I have filed a representation for encaderment, but decision has not been taken. Kindly issue a direction to the Speaker and the Commissioner and Secretary to dispose of my representation. The counsel for the Speaker appeared on that day, although notice was yet to be issued, and then considered that, yes, we can consider her representation. There is no harm by doing that. And then her representation was considered, and then pursuant to that consideration, this order has been passed. That is first part. The second part, which talks about the 1996 order of the Speaker, it is not in the form of an order, but in the file, in the note sheet. The Speaker has made an observation that way back in 1996, actually, we intended to create this post as a channel cadre, but why it was placed outside the channel cadre? But our intention of this post was to be included in the channel cadre. That was the noting in the file way back in 1996. Basing on that noting, they have issued the order. So that is all about the last paragraph, which unless it is projected, then we will not know. That is why I'm just making this clarification. Now, so far as this notification of 1st November 2021 is concerned, office memorandum is concerned, this was challenged by 4 petitioners on the ground that, look, we are governed by the service rule. Service rule do not permit, and the manner how she has been brought to the channel cadre is not permissible under the law. And this has obstructed our promotional avenues because we have a right to be considered. That was the contention, because this respondent number 3, she was holding an ex-cadre post. She was appointed in a cadre post, that is assistant transport officer, and then she was promoted to the post of senior transport officer by upgrading the post personal to the incumbent. Thereafter, by a subsequent order, it appears that the post of transport officer has been made as a sanctioned post, and it is a cadre post. But thereafter, beyond that, senior transport officer post was also created, upgraded, personal to the incumbent. It is an ex-cadre post of senior transport officer, which is an ex-cadre post, and she was made to be promoted to that post by the upgraded post, personal to the incumbent. And it is clearly mentioned in the order that the moment she is reverted ghost, the post will be reverted back to the sanctioned post of senior transport officer. So thereafter, again, she was upgraded. The post held by the petitioner has been upgraded to that of the Joint Secretary Transport. And there also, it is categorically mentioned that she will be reverted back to the original post. Thereafter, again, to the post of Additional Secretary, upgraded personal to the incumbent. And while she was holding that post of Additional Secretary, by this office memorandum, she has been brought to the cadre. After marching the shortcut, after reaching the targeted post, they have brought in. That was challenged. No, this cannot be done. This Honorable Court, by judgment and order dated 12/5/2022, has categorically came to a finding that, look, respondent number 3 is not holding a substantive post. It is an ex-cadre post. So this cannot be brought to the general cadre. That was the direction. However, if the respondents wants to restructure their cadre, then you can do so, but that can only be done in accordance with law and taking into consideration of all the stakeholders. That was the categorical direction given by the court. Now, within 6 days, on 18th of May 2022, the new amended rule, which is under challenge, has been passed. And the petitioners are agreed by that lordship. So I'm just citing the background so as to decide this case on consideration of all the facts and taking into consideration of all the relevant factors, lordships. And next page is notification issued on the same day, page 104, that is 1st November 2021. By this notification, the post of additional secretary, which was brought in to the general cadre, has been regularized in the post of additional secretary. This has also been quashed by the judgment and order dated 12/5/2022. So put the orders, office memorandum of 1/11/2021 and the notification of 1/11/2021 has been quashed by this honorable court. And as per the earlier rules, interchangeable was made possible, but by the new amended rule, it was made possible, lordships. Before I summarize my submission, lordship, this is the upgradation orders, which was the documents relying on which the earlier writ petition has been disposed of, WPC 323 of 21. Right from the post of transport officer, the post held by the private respondents have been upgraded personal to the incumbent. Therefore, all along her service career up to the rank of additional secretary transport, she was holding an ex-cadre post. She has not been brought to the cadre, and on 1st of November 2021, she was tried to brought into the cadre, but that has been challenged and that has been quashed. So the situation is, she has not been brought to the cadre as yet till date. However, by the amended rules, by making the post, there can be no distinction above the post of joint secretary. No distinction. That means all were made equals. And our contention is unequals have been made equal. Therefore, it is illegal. She was holding an ex-cadre post all along, not the cadre post. But indirectly, because they have not said that she is brought to the cadre. Because if they do that, there is the judgment of the honorable court that no, it is not possible. Therefore, in order to overcome the order passed by this honorable court on 12th of May 2022, they have done it systematically and very cleverly done. I must appreciate your ingenuity, how they have tried to do it. That is demonstrated by amendment of Rule 10. Earlier, in the old service rule, in the Rule 10P, it was not possible for intertransferability between the cadres. By making the amendment, they have made it possible in the sense Rule 10A has been amended in this manner. There can be no interchangeability, intertransferability between different schedules below the rank of joint secretary. No interchangeability. I cannot go, they cannot come. But after crossing the rank of joint secretary, Joint Secretary and above, we have not said that there can be transferability of the post above Joint Secretary. We have not said that. But my question is, since under Rule 10, Clause A, you are saying, because we belong to the same department, same employee, same cadre, below Joint Secretary, you are saying that no transferability. If transferability is possible above Joint Secretary, why not you say directly that above the post of Joint Secretary, indeed transferability is possible? Let them say. But they have not said that. Why? Just to overcome the order passed by this Honorable Court on 12/5/2021. Because there, you cannot do it. Clear finding has been arrived. And they have not challenged. Therefore, the only alternative for the respondents to overcome the judgment was to amend the rules. But how to amend the rule? Condition has been laid down by this Honorable Court that look, do it in accordance with law and by taking into consideration of all the stakeholders. Specific direction has been given. Why that was not followed? We are not saying that they have not power. They have ample power. Legislative competence they have. Under 187 Clause 3, they have the power to make rules. We are not saying that they don't have the power to make rules. They have power to make rules. But that power has to be exercised in accordance with law. That is what this Honorable Court has said. What prevented you to do that? That is our question, Lordship, in this petition. Therefore, we have taken the point that what cannot be done directly, you cannot do it indirectly. And in this particular case, they have done it indirectly, what they cannot do directly. That is one. Another point is, about the Joint Secretary. Frankly, if you are bringing her to the cadre, yes, so-and-so is in cadre. You have the power, you can do it. But how they have done? There can be no distinction of the grades, cadres, above Joint Secretary. Below Joint Secretary, no transferability. But after crossing that, since she has already crossed the bar, she wants to come and occupy the post of Secretary. Therefore, no distinction. So everybody should be equal. What are the posts? As I was submitting, of course, it will be at the course of repetition, but this will be relevant at this point of time. There are only 3 posts above Joint Secretary in the entire Assembly Secretariat under the rules. One is the General Cadre. There are 2 posts of sanctioned posts of Additional Secretary in the 3rd Schedule A. Now, one is occupied by the petitioner number 2. Another post which was fallen vacant in 2021. And the petitioner number 1 in the WPC 323 of 21. He has succeeded in the case, but his case has not been considered for promotion even till now. Why? The officer who was holding the post of ex-cadre post in the rank of Additional Secretary has come and occupied the post of Additional Secretary. Therefore, the petitioners in WPC number 323 of 21 has not availed the fruit of litigation. Otherwise, he was due for promotion, but his case has not been considered till date. That is also one aspect. So 2 posts, sanctioned posts in the rank of Additional Secretary. Another is the OSD to Speaker, which post was created only for the stenos. But no doubt, yes, the pay scale is same. But lordships are well aware, pay scale is the last criterion to compare the equivalence of posts. Last criterion, a set of plus case are there, and there are other cases as well. And no doubt, OSD to Speaker's creation of post is in the equivalence pay scale of the additional secretary. Equivalence, yes, in the equivalent rank that was created, but that was created only for the stenos. And the qualifications for the stenos are prescribed under the rules. We are not eligible because we don't have the stenography certificate. That is one. The another post is the one which can be treated as equivalent, according to them, is the additional secretary post transport, which is an ex-cadre post. She is still holding an ex-cadre post. Therefore, a sanctioned post and an ex-cadre post, how it can be equivalent. And she has not been engaged till date. And I would like to ask a question to the respondent authorities. Who has framed the rule? What do you mean by no distinction? No distinction means how it is done. Lord Chairman, kindly just for a moment. Lord, I will take your lordships to page 46 of the writ petition. This is how they have replaced Rule 10. Earlier, it was not possible. It starts from 45. In Rule 10, under the caption, streamlining of existing gatherers, the existing clause A and B are replaced as following. And then page 46 on the top, A, this is the relevant rule now which is applicable, which they have framed, which is under challenge. There shall be no intertransferability between the gatherers' schedules up to the rank of joint secretary. So that is clear, no transferability. But B, we are concerned with this. There shall be no distinction of cadres above the level of joint secretary in the assignment of duties, distribution of work, and for all other service matters. And for all other service matters, if that is covering the entire thing, what is the point of mentioning about assignment of duties, distribution of work? All other service matters will cover everything. It will cover the assignment of duties. It will cover the distribution of works. Now, what is meant by no distinction of cadre? You mean to say that an ex-cadre post is equivalent to the cadre post? You mean to say that OST to the speaker should be made equivalent to a post which is under third schedule A? To my mind, lordships, they are unequals. They are not equals. But the amended rule has shown there shall be no distinction of cadre. If they want to say, like A, there shall be no intertransferability between the cadre schedules. Directly you say in clause B also, there shall be transferability of the cadres above the post of joint secretary. Very clearly, directly. Clause A is very clear. Clause B is there not any ambiguity there? What do you mean by distinction of cadre? What do you mean by cadre? She is an ex-cadre. We are the cadre. So, how an ex-cadre and a cadre post can be equivalent? It is not equivalent. But in practice, they have demonstrated that she is asked to hold the post of secretary now, current charge, and additional secretary. A person who is not eligible to be promoted to the post of additional secretary, how current charge can also be given to the post of secretary? Very simple. Now, for promotion to the post of additional secretary from the post of joint secretary, it is only by promotion, not by making the post equivalent. And the respondent number 3 is holding an ex-cadre post Once she goes there, the post, she will be reverted back to the post of transport, which is the sanction post, which post is below the rank of joint secretary. Transport officer is a sanction post. The moment she vacated, then she will come back to the post of transport officer. Orders are very clear. So transport officer post is below the rank of joint secretary. So not intertransferability. So what was the intention of the lawmakers? That is why we are submitting that it is the tailor-made. How? On two grounds she wants to be benefited. By inserting the word there shall be no distinction of cadre, then I'm holding the next cadre post, so I can come. Even if she fails there, at least she has a safety valve under column 7, that is third schedule, column 7, eligibility criteria. There, the post of secretary can be filled up by promotion, deputation, and contract appointment. And a new word they have added, or equivalent. Equivalent word has been added. Therefore, she wants to benefit by inserting the word equivalent, that look, I'm equivalent to so-and-so, so I can come and occupy the post. So her target is to how to reach the secretary. With that object, giving in mind, giving in view of all this target, this rule has been amended. That is our allegations against the respondents' lordships. The manner how it has been designed is in such a way that in order to circumvent the order passed by this honorable court, this has been done. And by making this rule, who are benefited? I submit, lordships, only one person is benefited by this, that is the respondent number 3. Even in future, after she left the post, others are not coming, so they will not be benefited. Below the rank of joint secretary, they cannot come because this post is just upgraded, personal to the incumbent. Once he goes, nobody is there. It will not be benefited. Therefore, we are questioning the process of the legislation also. How? No doubt, we are not questioning that you do not have the power. And my learned friend, because this matter was heard on earlier occasion on 2 days, and they have been making submission that we have the power to do it. We have the administrative power to assign which responsibility to them. Yes, all this are admitted fake, and I have no argument on that. They have the power. Legislative competence, yes, they have. But this has been done in violation of the order passed by this honorable court. Paragraph 22, 24, and then 25, 35. In categorical terms, respondent number 3 is holding an ex-cadre post. She cannot come to the cadre. There is already a judicial finding on this. Therefore, the present amendment is contrary to the order passed by this honorable court. So, let me just conclude by summarizing my submissions, lordships. On the legislative confidence, there is no argument at all from my side. They have the power. They can do it. So it is not necessary to waste time on that. And the employer has also the power to amend the service rule under Article 187, Clause 3, or maybe under any other law. The employer has the power to make changes in the service rule. No argument on that. Admit it. They have the power. And the judicial review on all these issues are very limited. I also admit, yes, very, very limited. Thirdly, there is always a presumption in favor of the constitutionality. That is also admitted. I'm not arguing on all this. But there is one thing there. The burden of proof, the onus, lies on the person who alleges about the arbitrariness, unreasonableness, and illegalities. Onus lies, burden lies on the person who is making the allegations. And I believe I have been able to show how this is illegal, how this is arbitrary, how this is unreasonable, how an ex-cadre post holder can be made equated with a cadre post. Next is, Lordships, making the post equivalent, because by the amendment, the posts have been made equivalent. Making the post equivalent do not confer a right, do not accrue a right to hold a sanctioned post. Making the post equivalent do not confer a right on any employee to hold a sanctioned post in the cadre. She has not been brought to the cadre. Once she was brought, and that has been deferred by this honorable court. That has been quashed. Therefore, Lordships, my submission is, unless there is an order bringing her to the cadre, she is not holding a cadre post. And she cannot be said that she is in the same cadre. We belong to a different cadre. She has not come to the cadre as yet. Next point is, Lordships, the entire issue in WBC number 323 of 2021 was about encadrement and restructuring of the cadre. The whole issue in WPC 323 of 21 was about this encadrement of respondent number 3. Bringing to the residual, changing the residual. In the present case also, the amendment of Rule 10, A and B, others are also there, but I'm confining to Rule 10. They have done what this honorable court said, no, you cannot do it. That is not proper. They have done it. Therefore, what this honorable court has said that it is not possible, they have done it, they have shown that it is possible. There is a categorical finding by this honorable court. No, you cannot do this. But directly the same thing they have done. Only the word equivalence has been used instead of interchangeability. Therefore, is contrary to the order passed by this honorable court. That is one. Secondly, this is to circumvent the order passed by this honorable court. They cannot do indirectly, which they cannot do directly. And they have done something indirectly, which they cannot do directly. And this may lay down a bad precedent in the department. And there is a clear finding, clear direction, clear observation by this honorable court in the judgment of 12th May 2022, where it is said that if you want to restructure the cadres, then that can be done. Only, the word only is used, only be done in accordance with law and taking into consideration of all the stakeholders. In this regard, Lordships, I just want to point out one thing. In accordance with law, what can be treated as in accordance with law? As whatever repetition, for encadrement, for restructuring, a cadre review committee is constituted. That was the practice in the last two occasions in 2005 and 2009 when the rule was amended, 2005 and 2012, they have constituted the cadre review committee. They have examined, submitted the report. On the basis of that, they have amended the rules. So what prevented the authorities to act on the basis of the recommendation of the cadre review committee, which was already pending? Other day, I have placed the orders about the constitution of the cadre review committee, and it was pending, but within 6 days, they have amended the rules without taking recourse to the law. Therefore, I would like to submit that to do restructuring and encadrement in accordance with law, the proper procedure is to do it through a cadre review committee and take appropriate decision. We may be affected also, but that is the process of law. And such a practice can be treated as in accordance with law. Second part, to take into consideration of all the stakeholders. Who are the stakeholders? We are all employees of the stakeholders. So at least we should be taken into consideration and rules should have been amended. But then the direction has not been complied with. To that extent, we are agreed, and the present amendment is also in violation of the court order. And the amendment is also tailor-made. Since I have been making submissions for the last 3 days, I don't want to repeat it again and again. In short, it's tailor-made so as to suit the present respondent number 3. And even now also she is benefited. She is holding the current charge of secretary, who do not have the right even to hold the post. She is holding an ex-cadre post till date. Therefore, the entire action is arbitrary, unreasonable, and violative of Article 13 and 14 of the Constitution of India. Revocation order, Lordships, yesterday I could not furnish the copy. The revocation of the constitution of the cadre review committee. It was revoked on 27 2022 when this writ petition was pending. So this has been done so as to frustrate the pending litigation, because we have taken a point that, look, 2-3 committees have been constituted by several orders, and we are examining this. The committee is examining. Then what compels you to ignore this and go ahead with the amendment of the rules? Therefore, Lordships, unless the judgment is violated, this present amendment of 18/5/2022 cannot sustain. Unless the rules are violated, this is not workable amendment, workable rule. This is unworkable. I wish to conclude, Lordships. Much obliged, Lordships.
May I please, Lordship? Lordship, I'll be brief. I will not take much time. I will try to conclude within 1 hour, Your Lordship. Now, may I take Your Lordship to page 45, the writ petition. This is the amended rule, which is under challenge, Your Lordship. Lordship has got it. Now, what is being challenged? Para 2, Your Lordship. The amendment made to Rule 6, in Rule 6, Para 2, the word for a period not exceeding 3 months shall now be read as for a period not exceeding 6 months. The principal, may I take your lordship to the principal rules, page 19. Page 19, your lordship has got it. Now, Rule 6, it reads as under. Function of the board, to create such number of temporary posts as the speaker may from time to time create or upgrade on the recommendation of the board subject to the budget provision. This remains as it is. What has been amended is the subpara, provided that it shall not be necessary to consult the board or finance department for entertaining a post in the cadre of subordinate and grade 4 staff for a period not exceeding 3 months. Your lordship. Now, these are purely temporary posts. The petitioners, they are all are holding regular posts. They are regular member of the service in the Nagaland Legislative Assembly Secretariat, your lordship. Now, as held by the constitutional bench, by the apex court, and which has also been admitted by the learned senior counsel for the petitioner himself, when there is a challenge made to the virus of a rule, there is always a presumption of constitutionality of an enactment, your lordship. The other day, I've referred to the case laws, that is by Constitutional Bench Subramanian Swami's case. I will not take your lordship to that, but just the citation, 2014, Volume 8 SCC, 2014, Volume 8 SCC, 682. During my preliminary objection, I have already referred to that, your lordship. Now, therefore, the burden lies on the petitioner as to how and in what manner the amendment to proviso to Rule 6 infringes their fundamental right, your lordship. And as I've said, your lordship, these temporary posts, the petitioners are all holding regular service, your lordship. In the whole pleading, and in fact, no submission also has been made. The pleading is totally silent, and even the submission, the petitioners are completely silent as to how their fundamental right has been infringed by this amendment to Rule 6, your lordship. Therefore, in my respectful submission, your lordship, the challenge to this rule, Rule 6, Para 2, amendment made, is not legally sustainable, your lordship. Now, coming to the second challenge, your lordship. That is Para 3. Rule 9 may I read on? Rule 9 shall be replaced as follows. Recruitment to the post or class of posts may be made by any one of the following methods, namely A, by promotion, B, by deputation, C, by direct recruitment, D, by contractual short-term contractual engagement. The deputation or short-term engagement shall be for an initial period not exceeding 3 years, extendable by up to 2 years. The deputation or short-term engagement period shall be extended based on the performance as assessed by the appointing authority. For a moment, may I take your lordship to the pleading, Para 10 of the writ petition? Just to save time, your lordship. What is the ground taken by the petitioner in challenging these amended rules? May I read out? That the petitioner begged to state that Rule 9D, that is, by short-term contractual engagement in the service rule, had been inserted with ulterior motive. Motive is question, so as to serve the vested interested person. The petitioner also begged to state that the Rule 9D of the new amended rule defeats and violates Section 3(1) of the Nagaland Retirement from Public Employment Act, wherein it mandates that a person in public employment shall hold office for a term of 35 years from the date of joining public employment or until he attains the age of 60 years, whichever is earlier. It is stated that the Retirement Act is made applicable to the employees of the Nagaland Legislative Assembly and thus discharging full administrative power after retirement from regular service will be held to be illegal, and as such, the process of amending the service rule is illegal. The process is challenged, unreasonable, and irrational. Therefore, the same is liable to be interfered by this honorable court. That the said action is also in violation of OM dated 15/3/2012, where government has banned the extension of service of, or re-employment of government servant who has attained the age of superannuation on completion of 35 years in service or otherwise. Now, may I take your lordship to Annexure P, page 101. Just the relevant portion of the Retirement Act. 101, this is amended one, 102, page 102. May I read out this section? The bottom, section 2, amendment of section 3 of the Nagaland Section. Sir, lordship has got it. Notwithstanding anything contained in any rule or order for the time being enforced, a person in public employment shall hold office for a term of 35 years from the date of joining public employment or until he attains the age of 60 years, whichever is earlier. A person, now he will retire 60 years, whichever is earlier, your lordship. Now, next, may I take your lordship to the OM, which is at page 89. Petitioners, they are relying on this Retirement Act and then this OM at page 89. 89. Lordship has got it? May I read out? This is the OM dated 15th of March 2012. May I read out? Ban on extension re-employment of government servant. Attention of all concerned is invited to this department office OM such and such, whoever the government has banned extension of service or re-employment of government servants who have attained the age of superannuation on completion of 35 years in service or otherwise. It is hereby reiterated that no extension of service or re-employment of retired government employees as consultant, advisor at any level shall be resorted to by the department without prior clearance of PNR department, which will be considered only on exceptional and very special ground, your lordship. Now, I have replied to this in my affidavit in reply. Just to cut short, my lord, may I just refer to my counter affidavit at page 9. This is my reply to para 10. Lordship has got it? May I read out? That the statement made in para 10 of the writ petition is not correct, both in fact and law. For ready reference, section 3.1 of the Retirement Act, that is, I've done. Next para, section 3.1 of the Retirement Act only provides that a person in public employment shall hold office for a term of 35 years from the date of his joining public employment or until he attains the age of 60 years, whichever is earlier. It does not debar the state from appointing retired officials on contract basis. Therefore, Section 9D of the Service Rule 2022, which provides for short-term contractual engagement, cannot be said to be in contravention of Section 3.1 of the Retirement Act, your lordship. Now, the deponent further states that the OM dated such and such, relied upon by the petitioner, also does not impose a total ban on extension and re-employment of retired government employees. It has been categorically mentioned in the OM that such extension re-employment can be resorted to by the department after prior clearance of PNR department, which will be considered only on exceptional and very special ground. Now, this is for ready reference. Therefore, it cannot be said that the Service Rule 2022, amended Service Rule, which is under challenge, is violative of the OM dated 15/3/2012. Even otherwise, the OM dated such and such cannot override statutory rules. In fact, the OM itself provides for extension re-employment of retired officials by following due process, and the same has not been challenged by the petitioner, Your Lordship. Now, Your Lordship, therefore, the Retirement Act, Section 3(1), which has been relied upon by the petitioner, and also the OM, both the Retirement Act, Provisional Retirement Act, and the OM relied upon by the petitioner, Your Lordship, does not impose a complete ban on re-employment of retired government officials, Your Lordship. Now, so in no way, the amended rules either violates the Retirement Act nor the OM, Your Lordship. Therefore, the petitioners, the challenge made to Rule 9, Your Lordship, it is not legally sustainable, Your Lordship. Now, the next challenge, may I take Your Lordship to page, again back to page 45, Your Lordship? Para 4, the last line. In Rule 10, under the caption streamlining of existing cadre, the existing clause A and B are replaced by the following. And this is the main distinct attack. There shall be no intertransferability between the cadres scheduled up to the rank of Joint Secretary. There shall be no distinction of cadre above the level of Joint Secretary in the assignment of duties, distribution of work, and for all other service matter, Your Lordship. Now, Your Lordship, what the amended Rule 10 has done is the existing cadres have been streamlined, Your Lordship. The other day, the Learned Senior Council has also taken Your Lordship to the schedules, where, Your Lordship, in the Nagaland Legislative Assembly Service, Your Lordship, there are different wings, Your Lordship, 8 wings altogether. But for promotion to the post of Joint Secretary and above, Your Lordship, there is promotional avenue open only for the general wing, and to which the petitioners belong. But by streamlining the cadre, by this amendment, by incorporating this, Your Lordship, Rule 10 and B, Your Lordship, now promotional avenues has been opened to all other wings. This is not in the interest of the petitioner, Your Lordship. Now, in order to deprive those members who belong to other wings promotional avenues, Your Lordship, this writ petition has been filed. Yesterday, the Learned Senior Council was saying that the respondent has some hidden agenda. But this is the hidden agenda why the petitioner is before this court by filing this writ petition challenging the rule, Your Lordship. Now, perhaps, Your Lordship, Your Lordship, this aspect of the matter was also taken note of by the learned single judge in WPC 323, Your Lordship. And therefore, while giving liberty to the respondent to restructure the cadre as per the law, a positive direction also been given, Your Lordship. While doing so, to take into consideration the interests of all the stakeholders. The other stakeholders are not the general wing, not the petitioners, but the other wings, Your Lordship, if I have understood correctly. And perhaps this has been also taken into consideration while giving this positive direction, Your Lordship. Now, by the amended Rules 10, by incorporating this A and B, Your Lordship, a meeting point of different cadres, just like geology and mining also there, where there are different wings, Your Lordship. There's a meeting point. So that after that, those are purely administrative work. They discharge as administrative function. So that promotional avenues are given to all from different wings, Your Lordship. So a meeting point has been made at the level of Joint Secretary so that there is promotional avenues at, at the level of Joint Secretary, the meeting point, so that promotional avenues is given, is provided, right? And all members in the service, in government service, government employees, Your Lordship, at least they have a right to be considered for promotion. Some promotional avenues has to be there, Your Lordship.
Mr. TV, just one
Your
clarification.
Lordship.
This B, there shall be no distinction of cadre above the level of joint secretary.
Yes. Because from different wings, Your Lordship is correct. For different wings, qualification, prescribed eligibility are different. They will come in the non-promotion.
What the counsel for the petitioner is saying is that your cadre, your post, the highest post is only up to the level of transport officer.
I'll be coming to that, Your
So
Lordship.
we are a little confused with that.
I'll be coming to that. I'll be coming to that with case laws, in fact, Your Lordship. I'll satisfy that.
Okay.
Now, therefore, Your Lordship, the meeting point has been provided at the level of Joint Secretary, taking into consideration the interests of all the stakeholders, Your Lordship, and in fact, which is also in consonance and in terms of the direction passed by this Honorable High Court in writ petition 323, Your Lordship. Therefore, Your Lordship, by this amendment, by incorporating Rule 10 A and B, Your Lordship, no fundamental rights of the petitioner has been infringed, and therefore no interference is called for, Your Lordship. And just because the meeting point has been made at the level of Joint Secretary, it doesn't mean that the petitions have been deprived of their further promotion, Your Lordship. In fact, it has created a level playing field, Your Lordship. All members in this who are in service, Nagaland Legislative Assembly Secretary, Your Lordship, at least they have been given a promotional avenue, right to be considered. They may be promoted or may not, but at least that avenue, that channel of promotion has been opened for them. Now, next challenge, Your Lordship, is at Para 5, Your Lordship. Rule 12. Lordship has got in. Under the caption Appointing Authority, the existing sub-rule 1 is replaced by the following. The Secretary and Additional Secretary shall be appointed by the Governor on recommendation of the Speaker in consultation with the Chief Minister. This has been added. Now, Your Lordship, the post of Secretary in the Assembly Secretary, Your Lordship, see, he holds a very responsible post. And in fact, his post can be compared with that of the post of Chief Secretary in the Civil Secretariat, Your Lordship. May I take Your Lordship to the rule, Rule 3, page 19. Page 19, Your Lordship. Lordship has got it. May I read on? Secretariat is strength and composition. There shall be a separate Assembly Secretariat independent of the financial and administrative control of the government under the superintendence and control of the Speaker. So Assembly Secretariat, Your Lordship, just like Civil Secretariat also, it is independent of the financial and administrative control of the government. Next, so it is a totally an independent body. Rule 7, Your Lordship, just the opposite. On the other side, right-hand side, may I read out? administrative and control of the Assembly Secretariat. The Secretary shall, on the authority of the Speaker, administer the Secretariat and exercise full control over the officer and staff of the Assembly Secretariat and shall be responsible for functioning of the Secretariat, Your Worship. Now, as per Rule 3, Assembly Secretariat is independent of the financial and administrative control of the government and is under the superintendence and control of the Speaker. Now, under Rule 7, the Secretary, Assembly Secretariat, he exercises full control over the officer and staff of the Assembly Secretariat and is responsible for the functioning of the Secretariat. Therefore, the duties and responsibilities discharged by the Secretary in the Assembly Secretariat, that is why I'm saying, can be compared or equated to the post of Chief Secretary in the Civil Secretariat, who is also responsible for the functioning of the Civil Secretariat. Not only that, Your Lordship, just like the Chief Secretary, who is also the Cabinet Secretary, Your Lordship, the Secretary of the Assembly Secretariat is also the Secretary of all Assembly committees as per rules of procedures and conduct of business in the Nagaland Legislative Assembly, Your Lordship. Therefore, just as Chief Secretary, Your Lordship, the Secretary, the Assembly Secretary, Your Lordship, also requires absolute confidence of not only the Speaker, but also the ruling dispensation, Your Lordship, for smooth functioning of not only the Assembly, but also for conduct of business in the Nagaland Legislative Assembly, Your Lordship. Now, therefore, the amended Rule 12 provides that the Secretary shall be appointed by the Governor on the recommendation of the Speaker in consultation with the Chief Minister, Your Lordship. Now, the post of Additional Secretary is also equally important and responsible post. And this provision has been made, amendment has been made. And by the amended rules, Your Lordship, my respectful submission, petitioner has failed to show how their fundamental right has been infringed. And therefore, no interference is called for, Your Lordship. Now, next challenge is, Your Lordship, Para 6A, under Rule 15, it relates to APAR. Petitioner has no grievance, they are not pressing it. So I'm not necessary to make any submission on this, Your Lordship. No, on APAR. The next challenge, Your Lordship, is Para 7. In third Schedule A, against serial number 1, column 6, the following shall be replaced. The following shall replace the existing entry. Now, deputation. Now, the petition is mainly aggrieved by the contract of his submission. As superintendent officer who is otherwise eligible to be appointed on deputation not exceeding the age of 65 years. Now, Your Lordship, as I have submitted, neither the Nagaland Retirement Act, Section 3.1, nor the OM dated 15/3 of 2012, which is relied upon by the petitioner, the imposes a ban, total ban on re-employment of retired government employees, Your Lordship. In fact, in the OM, which I have read out, Your Lordship, OM, it lays out the procedure to be adopted as and when re-employment of retired government servants is resorted to by the government. And Your Lordship, it is also a well settled by the IPS Court that re-employment of retired personnel is within the executive power of the department, Your Lordship. Now, to satisfy Your Lordship, I may be allowed to refer to a case law 2019, volume 19 SCC, 87, page 87, paragraph 14. Or 2019, volume 19 SCC, 87. Lordship has got it, 2019, volume 19. The list of books I've given day before yesterday, so the many books are there. 2019, volume 19, SCC, 87. Oh. Seven, 8, 10, 12, and 14. I'll just read out the relevant portion.
On what subject?
On re-employment, Your Worship. Oh.
Yes.
29. May I just read out, Lordship? I'll just read out the relevant portion. The learned counsel for the state referred to government OM data such and such, re-employing. This is an appeal filed by the state of Telangana. Learned counsel for the state referred to government order number such and such, re-employing Sri Sampat Kumar, Joint Director, Anti-Corruption Bureau as officer on special duty after superannuation on such and such for a period of 1 year. Such order of re-employment was renewed, such and such, extending the term of re-employment by 1 year. The High Court, para 8, the High Court relied upon the judgment in UPSC versus Giri such and such to hold that statutory rules do not permit to extend the age of superannuation. Now, para 10. Article 310 of the Constitution contemplates that except as expressly provided, every person who is a member of a defense service or of a civil service of the Union or of an all India service or holds any post connected with defense or any civil post under the Union holds office at the pleasure of the President. This is a constitutional provision. In respect of the state service, however, he or she holds office at the pleasure of the governor. In the present case, Sri such and such was re-employed for a period of such and such by the state government in excess of power conferred under Article 162 of the Constitution of India. There is no provision in any service rule that there cannot be any re-employment of a person who was once in the civil service of either the center or the state. Now, para 12. In PA such and such, it has been held that the executive power of the state is coterminous. Okay, we can leave out this. Para 14. Sri K. Sampat Kumar was re-employed initially for a period of 1 year after his retirement. He was not being recruited for holding a civil post for the first time, which may warrant compliance of rigor of Article 16 of the Constitution. He has crossed all bridges when he was appointed and discharged duties before attaining the age of superannuation. Such re-employment by the state is in excess of power conferred under Article 162 of the Constitution of India. Such executive power of the state do not contravene any other statutory provision. Therefore, re-employment in this regard is supplementing the statutory rules and regulation and not supplanting them, Your Lordship. So in my respectful submission, Your Lordship, like employment beyond the age of 65 years on contract basis, beyond 60 years, Your Lordship, is within the power of the executive, Your Lordship. So, Your Lordship, and by this amendment, Your Lordship, no fundamental rights of the petitioner has been infringed. And as I said, Your Lordship, the petitioners, they are not questioning the legislative competence. So, in my respectful submission, Your Lordship, the challenge to the amended rules, Third Schedule A, Your Lordship, is not legally sustainable, Your Lordship. Now, next is B. In D, Your Lordship, here, in this connection, in Third Schedule A, such and such, the following shall replace the existing entry by promotion from the grade of additional secretary or equivalent in the assembly secretary with a minimum of 2 years continuous service in the grade, if deemed fit by the appointing authority, Your Lordship. Now here, the submission which has been advanced by the Learned Senior Council is that the amended rule is not based on rational basis, Your Lordship. There is no decision is not rational. Like there is no promotional avenue. That is why I'm coming to that. Your Lordship has put that query, Your Lordship. In other cadre, to reach the rank of additional secretary, or even below, due to non-existence of substantive posts. Now that is the query which Your Lordship has put, Your Lordship. Now, Your Lordship, as per the amended rules, the meeting point of all members in different wings, Your Lordship, is at the level of joint secretary, Your Lordship. Now, even if there are gaps in the hierarchy, Your Lordship, in my respectful submission, such gaps can be filled up by executive instruction, Your Lordship. And to support my submission, Your Lordship, I may refer to on case law, Your Lordship, AIR 1967.
This is on
Supreme Court.
filling up the gaps.
Yes. AIR 1967 Supreme Court 1910. This is by a constitutional bench, Your Lordship.
AIR.
AIR 1967 Supreme Court 1910. This is the first decision, Your Lordship. Para 7 and 8. Masih kamar. Yes, Lord.
We'll come back in 5 minutes.
Lordship, may I read out para 7, AIR 1967, Supreme Court, 1910, para 7 and 8. Lordship has got it.
Yes.
Now, fourth line from the bottom to save time, para 7. It is true that government cannot amend or supersede statutory rules by administrative instruction, but if the rules are silent on any particular point, government can fill up the gaps and supplement the rules and issue instruction not inconsistent with the rules already framed. 8. In BN such and such, it was pointed out by this court that it is not obligatory under the proviso to Article 309 of the Constitution to make rules of recruitment, etc., before a service can be constituted or a post created or filled. And secondly, the state government has executive power in relation to all matter with respect to which the legislature of the state has power to make laws, Your Lordship. Now, admittedly, even if there are gaps, Your Lordship, just gaps, Your Lordship, can be filled out by executive instruction. Next decision, Your Lordship, is 1984 for SCC, 1984, Volume 4 SCC, page 27, para 16, Your Lordship. Para 16, Your Lordship. May I read out? In our opinion, the aforesaid approach makes such a next. The court cannot sit in judgment over the wisdom of the policy evolved by the legislature and the subordinate regulation-making body. It may be a wise policy which will fully effectuate the purpose of the enactment, or it may be lacking in effectiveness and hence calling for revision and improvement. But any drawback in the policy incorporated in a rule or regulation will not render it ultra vires, and the court cannot strike it down on the ground that, in his opinion, it is not a wise or prudent policy, but is even a foolish one, that it will not really serve to effectuate the purpose of the act, Your Lordship. Now, Your Lord, now there may be some gaps, as Your Lordship has rightly pointed out, but such gaps, Your Lordship, that can be filled up by executive instruction. And Your Lordship, here, in fact, the petitioners, they are questioning the rationale of the decision-making process of the amended rules, Your Lordship. What the petitioner is questioning is the wisdom of the lawmakers, Your Lordship, and which, as held by the Honorable Apex Court, Your Lordship, it is not permissible, Your Lordship. Therefore, the ground taken by the petitioners in challenging the rules, amended rules, Your Lordship, is not legally sustainable. Now, in my respectful submission, Your Lordship, none of the amended rules, Your Lordship, they violate any of the fundamental rights of the petitioner. And from the submission which has been advanced by the learned senior counsel for the petitioner, subject to correction, Your Lordship, in my respectful submission, the main grievance of the petitioner is that the service rule has been amended without waiting for the report from the cadre review committee. And secondly, the amended rule is violates or it's in circumvention of the judgment passed by this honorable court, learned single judge in writ petition 323, Your Lordship, and against which no appeal has been filed and which has attained finality, Your Lordship. Now, on amendment of the service rule, Your Lordship, without waiting for the report from the cadre review committee, Your Lordship, what was the direction passed by learned single judge? Liberty was given to the respondent to restructure. but you do it as per the law. Why it was interfered, the earlier notification? Because the earlier amendment was made in exercise of Rule 22 of the Secretary Service Rule, which only empowers the Speaker to relax the rules, not to amend. Therefore, and rightly so, the learned single judge has directed that, okay, liberty was given, you can restructure, but then you do it as per the law. And accordingly, the rule which is under challenge has been has been passed in excess of power under 187(3), Your Lordship. The law does not say that report from cadre, if you have, once you have constituted a cadre review committee, the report has to be, there has to be a report, then only you can do. It is not a precondition, Your Lordship. That is not the law. And just because the Learned Senior Council has submitted that on earlier occasion, and for that purpose, Your Lordship, report has been called. An earlier occasion, whatever amendments were made, it was made only on receipt of a report from the Cadre Review Committee, Your Lordship. Now, just because in the past, Your Lordship, the service was amended only on receipt of a report from the Cadre Review Committee, Your Lordship, that will not give any legally enforceable right to the petitioners to insist that these rules can be amended only on receipt of report from the Cadre Review Committee. Or for that matter, whether this court can direct the respondent, no, you can amend only after you receive the report from the Cadre Review Committee. Whether such direction can be given, Your Lordship. So competency is not being challenged, Your Lordship. So in my respectful submission, Your Lordship, just because the service rule, which is under challenge, has been amended, Your Lordship, without waiting for the report from the Cadre Review Committee, that cannot by itself be a ground to interfere with the rules, Your Lordship, when the rules has been made as per the law in excess of power under Article 187(3) of the Constitution of India, Your Lordship. And even otherwise, Your Lordship, by the amended rules, what the respondent has done was only simply to restructure the cadre in the service, Your Lordship. And as held by the Honorable Supreme Apex Court, Your Lordship, restructuring of cadre is within the exclusive domain of the employer, Your Lordship. Therefore, even consent of the employee is not necessary, Your Lordship. Now, may I refer to one judgment, Your Lordship? 2008, Volume 9, SCC 242. 2008, Volume 9, SCC 242. Para 37. This, Your Lordship, is Pushpa Rani's case, Your Lordship. Pushpa Rani's case. I'll just read out the relevant portion. Before parting with this aspect of the case, we consider it necessary to reiterate the settled legal position that matter relating to creation and abolition of posts, formation and structuring, restructuring of cadre, prescribing the source, mode of recruitment, and qualifications such and such as are exclusively within the domain of the employer, Your Lordship. Now, next case, Your Lordship, 1974, Volume 1, SCC. 1974, Volume 1, SCC, page 19. This is also by a constitutional bench, Trilokinath. 1974, Volume 1, SCC, page 19. Para 16. May I read out? Para 16, Your Lordship. 9 line from the bottom to save time. It is well settled that though employment under the government, like that under any other master, may have a contractual origin, the government servant acquires a status on appointment to his office. As a result, his rights and obligations are liable to be determined under statutory or constitutional authority, which, for its exercise, requires no reciprocal consent. Supreme Court has even went to this extent. The government can alter the terms and condition of its employees unilaterally. And though in modern times consensus is matter relating to public service is often attempted to be achieved, consent is not a precondition of the validity of rules of service. Your Lordship. So it is not only within the exclusive domain of the employee, Your Lordship, even consent of the employee's lordship is not necessary when it comes to amendment of the rules, Your Lordship. Therefore, what the petitioner is trying to say is that had the cadre, because since cadre review, report of the cadre review was not placed, was not taken into consideration, or it was not even placed, that their views, their consent, or what their opinion was not taken into consideration. No, it is not necessary, Your Lordship. Therefore, the ground taken by the petitioner, Your Lordship, that this has been, the service rule has been amended without taking, without texting before the cadre review committee has submitted a report. That is not the law. That cannot be a ground, Your Lordship, to interfere with the rules, Your Lordship, which is under challenge. Now, next, whether the service rule, amended service rule, is violative of the judgment order, which is passed in writ petition 223 of 21. Judgment dated 12/5/2022. And as I've submitted, no appeal has been preferred, and it has attained finality. Now, for that, Your Lordship, just to save time, may I refer to my counter affidavit. Para 10, Your Lordship. When the preliminary objection was taken up, this paragraph was also read, but just to refresh Your Lordship's memory, para 10. May I read out? Lordship. That it replied to the statement made in para 11 of the writ petition, it is stated that this Honorable High Court, while setting aside the impugned OM dated such and such, and notification dated such and such, white judgment order dated such and such, has also observed that the same shall not debar the respondent authorities concerned from considering the restructuring of various posts under the Assembly Secretariat, which should otherwise only be done in accordance with the relevant provision of law and by taking into consideration the rights and interests of all stakeholders. It is stated that this Honorable High Court has quashed and set aside the OM dated such and such and notification dated such and such, as the same were not issued in accordance with the relevant laws. Accordingly, the service rule has been amended as per Article 187(3) of the Constitution of India, and restructuring has been done after taking into consideration the rights and interests of all the stakeholders, including the larger interests of the Nagaland Legislative Assembly Secretariat. It is stated that the fact pointed out by this Honorable Court has been removed by amending the service rule as provided under Article 187(3) of the Constitution of India by taking into consideration the rights and interests of all stakeholders. Therefore, the contention of the petitioner that amending the service rule has made the judgment and order that is such and such redundant and ineffective is not correct, Your Lordship. Now, as I've submitted, Your Lordship, what the amended rules which is under challenge, this has been amended in excess of power under Article 187(3) of the Constitution of India, Your Lordship, and after taking into consideration the interests of all the stakeholders, Your Lordship, and by providing a meeting point at the level of Joint Secretary, Your Lordship, and thereby providing promotional avenues to members who are in different wings, Your Lordship. In other words, by taking into consideration the interests of all the stakeholders. Now, Your Lordship, by the amended rules, only the defects pointed out by this court has been removed, and removing such defect, Your Lordship, is very much within the legislative competence, Your Lordship. May I take Your Lordship to one citation, case law 1997, 1 SCC 326, para 16. This is by a constitutional bench, 1997, 1 SCC 326. Para 16. But relevant portion, Your Lordship, will be at page 341. Para 16 is at page 340. I'll read out from the relevant portion, page 341, the 7th line. May I read out? It is open to the legislature to remove the defect pointed out by the court or to amend the definition or any other provision of the act in question retrospectively, Your Lordship. Now, this honorable court, but the learned single judge has said that no, it has not been done as per the rules, because it was the earlier amendment was made in excess of power under Rule 22 by the Speaker, which provides only for power to relax the rules. So the defect pointed out by this court, Your Lordship, that has been cured, Your Lordship. Another constitutional bench, Your Lordship, case citation 1989, volume 3 SCC, page 488. Page 488, para 65. This is also by a constitutional bench, Your Lordship. 1989, volume 3 SCC 488, para 65 is at page 517. Lordship has got it. May I read out? There is really no substance in the grievance that the retroactivity imparted to the amendment is violative of Article 19 such and such. A competent legislature can always validate a law which has been declared by the court to be invalid, provided the infirmities and vitiating factors noticed in the declaratory judgment are removed or cured. Such a validating law can also be made retrospective. If in the light of such validating and curative exercise made by the legislature, granting legislative competence, the earlier judgment becomes irrelevant and unenforceable. That cannot be called an impermissible legislative overruling of the judicial decision. All that the legislature does is to usher in a valid law with retrospective effect in the light of which the earlier judgment becomes irrelevant, Your Lordship. Now, next law, authority, Your Lordship, 2020, volume 13 SCC, page 585. Relevant para 29. This is by a 3-judge bench, Your Lordship. 2020, Volume 13, SCC 585. Ashwini, Lordship. Ashwini. 3 judge bench, Your Lordship. Now, 18 line from top. Now, supposing some guidelines are given, such laws, 18 line from top, I'm reading out, such law when enacted by Parliament or the state legislature, even if assumably contrary to the direction or guideline issued by the court, cannot be struck down by reason of the direction guidelines. It can be struck down only if it violates the fundamental rights or the right to equality under Article 14 of the Constitution, Your Lordship. Even if it violates, Your Lordship. The petitioner has to first satisfy that by this amended rules, Your Lordship, his fundamental rights has been violated, Your Lordship. That is therefore, Your Lordship, the grounds taken by the petitioner that the amended rules is violative or it circumvents the judgment order passed by the learned single judge in writ petition 323 of 2021 is not legally sustainable, Your Lordship. Now, in the course of your submission, Your Lordship, argument also has been advanced that the service rule has been made for the benefit of only certain individuals, Your Lordship. In other words, the petitioners are questioning the motive behind the amendment, Your Lordship, and which is not permissible as per the law laid down by the Apex Court, Your Lordship. 2016, Volume 16, SCC 111.
2016.
Volume 16, SCC 101, Para 7. Lordship has got it. May I read out? Para 7. Apart from that, 2016, Volume 16, page 101. 101. Para 7. Apart from that, the High Court made various other observations in the judgment regarding the manner in which the amendment were made and the desirability of such amendment. Such observations, in our opinion, are not warranted in the context of the issue before court. The High Court ought to have kept in mind that it was the legislative decision of the state which was the subject matter of dispute before it. While the High Court undoubtedly has the jurisdiction to determine the constitutionality of the law, the motives behind the law and the wisdom of the legislative body are not amenable to judicial review. Very clear, Your Lordship. And by questioning of motive behind the amendment, Your Lordship, as held by the Honorable Apex Court, Your Lordship, it is not permissible, Your Lordship. Now, last, Your Lordship, I'll come to the rules, the submission I've concluded, Your Lordship, on judicial review. On judicial review. Now, Your Lordship, as I've submitted the other day when I was raising the preliminary objection, and the power exercised by the governor under Article 187.3 is legislative in character, Your Lordship. Now, that it's okay, it's okay. I have already, if Your Lordship wants a citation, I can cite, can write down. I've already referred to that. 1980 supply SCC 524. 1980 supply 524 para 44. The governor exercises legislative power, Your Lordship. Now, on judicial review of order or rule made under the proviso to Article 187.3, Your Lordship. It's very rare, but fortunately, I've just come across one of this court's decision, Your Lordship. But that time, rules can be challenged before the single judge also. So this is decided by a single judge, reported in 1999, Volume 3, GLT 320. Mm. 1999, Volume 3, GLT 320. This is a very short judgment. I'll read out from para 1 itself. May I read out? This writ application has been filed with the prayer to be struck down. The rules were made in excess of power conferred by Clause 3 of Article 187 of the Constitution of India, just as in this case. And the rules were made by the Governor of Assam after consultation with the Speaker of Assam Legislative Assembly. The portion of the Rule 9.6 which is prayed to be struck down reads as follows. 9.6. Secretary to the Speaker. This also relates to the post of Secretary. By promotion from the post of committee officer or superintendent, the person possessing degree in Bachelor of Law of a recognized university may be given preference. The Speaker may also fill up the post from any other source, and the tenure of office of the person so recruited shall be coterminous with the office of the Speaker. Para 2. The portion of the rule which is prayed to be struck down provides that the Speaker may also fill up the post from any other source, and the tenure of office of the person so recorded shall be coterminous with the office of the Speaker. As pointed out by the Apex Court in AIR such and such, and subsequent decision, the law as follows. Now it is true that rules made under the proviso to Article 309 of the Constitution, in this case the proviso 187.3, being legislative in character, cannot be struck down merely because the court think that they are unreasonable, and they can be struck down only on the ground upon which a legislative measure can be struck down. In the case of McDowell such and such, the Supreme Court has pointed out as follows. This is also a constitutional bench. The power of Parliament, or for that matter, the state legislature, is restricted in two ways. A law made by Parliament or the legislature can be struck down by court on two grounds and two grounds alone, which lack of legislative competence and violation of any of the fundamental rights guaranteed in Part 3 of the Constitution or any other constitutional provision. There is no third ground. When a statute is impugned under Article 14, what the court has to decide is whether the statute is so arbitrary or unreasonable that it must be struck down, Your Lordship. Now, and this petition was dismissed, Your Lordship. Now, in my respectful submission, Your Lordship, like power of judicial review can be exercised, this court can, only if the petitioner can satisfy this honorable court that the amended service rule, it infringes their fundamental rights, Your Lordship. Now, in my respectful submission, the petitioners has miserably failed to do so. No fundamental rights whatsoever has been infringed by the amended service rule, which calls for the intervention of this honorable court, Your Lordship. Now, what the petitioner is, what the petitioner wants from this honorable court is to examine the decision-making process, how the decision was taken. Within 6 days it was passed, or the rule was amended without the report from the cadre review committee, or signature was electronically obtained, whatever. Those decision-making process, Your Lordship, cannot be gone into while examining the constitutional validity virus of the rules, Your Lordship. As I've said the other day, Your Lordship, this is not an award of contract. Award of contract where this honorable court, in exercise of power of judicial review, can examine the decision-making process, the file, call for the file, how the decision was taken, but not when virus of an enactment is being challenged, Your Lordship. Now, moreover, just attributing some ulterior motive that the service rule has been made or amended for the benefit of certain individual, that by itself cannot be a ground to make the amended rules unconstitutional, Your Lordship. May I refer to 1995, Volume 5 SCC, page 96. Volume 5 SCC, page 96, para 11 and 12. May I read out? The argument advanced on behalf of the petitioner that the 1991 Amendment Act was enacted by the Orissa State Legislature, which was actuated by malafide. The intention, motive has been questioned, and hence the same is unconstitutional, is difficult of acceptance. That malafide or ulterior motives attributed to the state legislature in making a law within its competence can never make such law unconstitutional, Your Lordship. It is well settled. This is what it is. In such and such, while dealing with the malafide attributed to a legislature in which it had competence to make the law, this court said thus. The legislature as a body cannot be accused of having passed a law for an extraneous purpose, for if no reasons are so stated as appears from the provision enacted by it, its reasons for passing a law or those that are stated in the objects and reason, even assuming that the executive in a given case has an ulterior motive in moving a legislation, that motive cannot render the passing of the law malafide. This kind of transferred malice is unknown in the field of legislation. Hence, we have no hesitation in finding that the 1991 Amendment Act cannot be held to be unconstitutional because of the ulterior motive and malafides attributed to the state Orissa state legislature, Your Lordship. Now, so the contention of the petitioner, Your Lordship, the service rule is discriminatory, is totally baseless. It is not to favor anyone, Your Lordship. In fact, this has been amended, taking into consideration the interests of all the stakeholders, Your Lordship. And a statutory provision, Your Lordship, unless it is found to be discriminatory, Your Lordship, that cannot be interfered with, cannot be struck down, Your Lordship. May I refer to, I have two more citations, I'll conclude. 2003, Volume 11 SCC, page 614. 2003, Volume 11 SCC, 614, para 45. Para 45, Your Lordship. May I read out, Your Lordship?
Yes.
In this case, the petitioners seek benefit to which they are not otherwise entitled. The legislature, in our opinion, has the requisite jurisdiction to pass an appropriate legislation which would do justice to its employees. Even otherwise, presumption to that effect has to be drawn. If a balance is sought to be struck by reason of the impugned legislation, it would not be permissible for this court to declare it ultra-vires only because it may cause some hardship to the petitioners. A mere hardship cannot be a ground for striking down a valid legislation unless it is held to be suffering from the vice of discrimination or unreasonableness. A valid piece of legislation thus can be struck down only if it is found to be ultra-vires Article 14 of the Constitution of India and not otherwise, Your Lordship. The last case law, Your Lordship, which I will be referring, 2012, Volume 6, SCC 312. 2012, Volume 6, SCC 312, Para 17. This is the last authority I have. Para 17, may I read on? This court has repeatedly stated that legislative enactment can be struck down by court only on two grounds, namely that the appropriate legislature does not have the competence to make the law and that it does not take away or abridge any of the fundamental rights enumerated in Part 3 of the Constitution or any other constitutional provision. In McDowell such and such, paragraph 43, a law made by Parliament or the legislature can be struck down by court on two grounds and two grounds alone: lack of legislative competence and violation of any of the fundamental rights granted in Part 3 of the Constitution or any other constitutional provision. There is no third ground. If an enactment is challenged as violative of Article 14, it can be struck down only if it is found that it is violative of the Equality Clause, Equal Protection Clause enshrined therein. Similarly, if an enactment is challenged as violative of any of the fundamental rights granted by subclause A to G of Article 19(1), it can be struck down only if it is found not saved by any of the clauses 2 to 6 of Article 19, and so on. No enactment can be struck down by just saying that it is arbitrary or unreasonable. Some or the other constitutional infirmities has to be found before invalidating an act. An enactment cannot be struck down on the ground that the court thinks it unjustified, Your Lordship. That's all. Now, Your Lordship, the amended service rule is not challenged on the ground of legislative competence, and the petitioners has failed to show how their fundamental rights or constitutional right has been violated by the amended service rule. Therefore, the writ petition, Your Lordship, is devoid of merit and is liable to be dismissed, Your Lordship. Just to sum up, Your Lordship, I'll take 5 minutes. Just to sum up, I'll take 5 minutes only, Your Lordship. Now, the amended service rule is neither violative of Section 3(1) of the Retirement Act, nor is violative of OM dated 15/3/2012, Your Lordship, which is being relied on by the petitioner. Now, the service rule, this has been amended as per law in excess of power under Article 187(3) of the Constitution of India, and taking into consideration the interests of all the stakeholders, Your Lordship. Now, the report of the Cadre Committee is not a precondition for exercise of power under Article 187(3) of the Constitution of India, Your Lordship. And the amended service rule, Your Lordship, in no way does not violate or circumvent the judgment passed by this Honorable Court in WPC 323 of 2021, Your Lordship. And in fact, it has removed or cured the defect as pointed out by this Honorable Court. And whatever amendment has been made, Your Lordship, is in consonance with the judgment passed by this Honorable Court, Your Lordship. Now, as the service rule has been amended in exercise of power under Article 87(3) of the Constitution, 187(3) of the Constitution of India, and which is legislative in character, Your Lordship, there is always a presumption of constitutionality, validity of the enactment, and that it can be challenged only on two grounds: lack of legislative competence and violation of fundamental or other constitutional rights, Your Lordship. Now, by filing this writ petition, Your Lordship, what the petitioners are questioning is only the decision-making process, Your Lordship, and the wisdom and the motive of the lawmaker, Your Lordship, which is not permissible as laid down by the Honorable Apex Court, Your Lordship. Therefore, Your Lordship, the petitioner has failed to establish how their fundamental rights or constitutional right has been infringed by the administrative rule. Therefore, Your Lordship, there is no merit in the writ petition. The petition is liable to be dismissed. Much obliged, I conclude, Your Lordship.
We'll hear you tomorrow. Meantime, submit your written arguments.
Lordship.
Lordship, we'll give you time.
Lordship.
Written submission maybe by the end of the week.
Yeah, by Friday?
By Friday, because to give written submission by tomorrow maybe.
No, we are not saying tomorrow. Before I leave.
Lordship, yes.
Mr. TV,
Lordship.
just to clear one confusion.
Lordship, please.
The Lieutenant Counsel for the petitioner has stated that you are holding an upgraded ex-cadre post, and your post has not been in cadre. So bringing you into the cadre service without in-cadring your service is not permissible. Can you kindly
Yes.
highlight
Lordship,
that?
the issue is this. My lord, there is only one cadre. The cadre is the members of the Nagaland Legislative Assembly Service. There are different wings. There are 8 wings, 8 schedules, 8 wings. And, my lord, because they require different requisite qualifications. For example, in geology and mining department, you have geologists, you have chemists, you have drilling engineers. 3 wings. And they all belong to one cadre. That is the services of geology and mining department. Now, that's how, Lordship, to clear the confusion, in the third amendment rule, Lordship, the word schedule/cadre is used. If you, Lordship, I'll clarify to on the third schedule. So, my lord, we are promoted with different qualifications, some in the technical wing, like librarians, stenographers, my lord, automobiles. And we come up in the different wings to the level of joint secretary. That is one aspect of the matter. Now, Lordship, so the issue was, the learned single judge concern was that whether a person can move from one wing to another wing. That was one aspect of the matter, and that which is a clear case of amendment.
That is whether one can move from one schedule to another schedule.
Yes.
By relaxing the rules.
So that is a clear case. So the learned single judge in 323 is that is a clear case that can be exercised through an amendment only under 187, not under the restitutory powers of the Honorable Speaker. That's how the case judgment was struck down.
I support your lordship. There's an order passed by this court on 23/8/2022 and directing me to produce a report. So I'm placing the report.
Okay. Then you do one thing. Order, so. New panel. Let Mr. T.B. Janda, General Counsel for Respondent 1 and 2 has produced the reports. The same is retained by this court. List on 2 tomorrow.
Obliged.
Khalid.